Welcome to the Macmillan Report. I'm Marilyn Wilkes, your host, and our guest is Bernhard Schima, the European Union Visiting Fellow at Yale University. Mr. Schima is a legal advisor in the European Commission's legal service. He has studied law in Vienna, where he was born, and in Paris and at Harvard Law School. From 1995 to 2003, he was a member of the Chamber of Judge Dr. Peter Jann at the European Court of Justice. He has taught and published extensively on various matters of European Union law. Today we talk with him about the application of EU fundamental rights to the member states after Lisbon and putting the case law of European Court of Justice into perspective. Welcome, Mr. Schima.
Thank you very much for having me.
Okay, so your research focuses on the application of the EU fundamental rights to the member states after the Treaty of Lisbon. So I guess we need to talk about what the Treaty of Lisbon is and also the EU fundamental rights, and then what actually changed when that happened.
Yes, well, the Treaty of Lisbon is the treaty which gave the foundations of the European Union its current form. Okay. Those are two basic treaties that have started to apply at the end of 2009. And when we talk about fundamental rights, we mean what you would normally find in some kind of a Bill of Rights, okay, right? The freedom of expression, the freedom of religion, freedom of association. And European Union fundamental rights were not originally included in such a Bill of Rights of the Union. Mm-hmm. It was rather the European Court of Justice which, in its case law, developed such fundamental rights as general principles of European Union law. Mm-hmm. And it found those general principles on the one hand by looking at the common constitutional traditions of the member states, and on the other hand by looking at international conventions for the protection of human rights to which the member states were parties.
Okay.
So what now changed with the Lisbon Treaty was that a binding set of fundamental rights was finally included as a proper source of European Union law. Okay. That so-called Charter of Fundamental Rights of the European Union was drawn up already in the year 2000, but at that time it was not made formally binding. So that is what the Lisbon Treaty now changed. It put it at the same level of the treaties and made it therefore a binding source of European Union law.
Okay, why was it not binding from the very beginning? Why did it have to become binding down the road?
Well, because member states are actually quite afraid, I think, some member states at least, that the European Union might start to look like a state. And normally, a binding set of fundamental rights, a Bill of Rights, is something that you typically find in a national constitution. Mm-hmm. And some member states who don't want the European Union to turn into a state would be quite concerned by that. This is why fundamental rights have only made their way into European Union law slowly and step by step.
Mm-hmm. Okay, how many member states are there who are now adhering to this?
There are today 28 member states. We started out with 6 member states of the Union and then it expanded. There was a very big expansion of the European Union in 2004 when 10 member states joined at once. And the latest accession was Croatia as recently as 1st of July 2013.
Okay, so now they are all operating under these same fundamental rights.
To a certain extent.
To a certain extent.
The problem here is that everyone can more or less easily accept that European Union fundamental rights should apply to acts of the European Union, right? The European Union is a treaty, is a treaty organization if you want, but it has its own institutions which act and adopt pieces of what we call secondary legislation. And the legislation adopted by those institutions certainly needs to be checked against fundamental rights.
Okay.
And that is what member states are still more or less comfortable with, because even if you are sort of skeptical of European integration, you're going to say, okay, fundamental rights are going to limit the action of the Union institutions, and we don't have to be so worried about a potential encroachment of the Union upon member state competencies.
I see. Okay.
Where it gets more problematic, though, is when you want to apply those same fundamental rights to the member states. In that case, the acts, the rules of one authority, let's say the union, are going to reach into the sphere of another authority, the member states. And the member states all have their own fundamental rights, of course. And they don't necessarily see why suddenly the rights of the union should also apply to what they do.
Can you draw on any specific examples of that becoming a problem with a particular country, for instance?
Well, there are, on the one hand, reluctances concerning certain countries, and on the other hand, well, general sort of misgivings about the way the Court of Justice has gone about that. Let me maybe start by explaining what the Court of Justice has done.
Okay.
There are certain situations in which it is probably necessary to accept the application of such fundamental rights to the states. That is the case when one can really say that the states are acting as agents of the Union. So the European Union institutions are going to adopt some general rules, and in order for all that to work in the member states need to fill that in. And when that is the case, when they are really implementing union law, well, one can easily justify that they also have to comply with the fundamental rights of the Union. Where it gets more problematic is where the Court of Justice has extended that case law and started to say that the same fundamental rights apply to the member states also when they are just acting within the scope of union law. And you see, of course, that that is a much broader and sort of vague notion. To give you maybe one example, sometime back in around 2000, the Court of Justice had to decide a case about a woman from the Philippines who was married to a national of the UK, and that UK national was occasionally providing services in other member states. He was traveling to France to sell advertisement space in some scientific journals, and during that time, apparently his wife was taking care of the children. Now the problem was that her residence in the UK was not legal. She had entered illegally and they had married, and she was actually threatened with expulsion. Now the question was, did she have a right to the protection of her family life as a matter of European Union law? And for European Union law to intervene there at all, one had to see, well, how far the scope of union law actually went. And what the court said, following the rather skillful lawyers of that couple, was that in fact, if the lady was expelled from the UK, her husband would no longer be able to provide services so easily, because there would be someone who would need to look after the children, right? Therefore, expelling her would restrict his freedom to provide services. Therefore, we were within the scope of European Union law, the freedom to provide services being guaranteed by the treaty, and therefore she enjoyed protection of her right to family life as a matter of union law. That was actually quite a far-reaching decision, and some member states may not have been entirely comfortable with that.
Because it now sets precedent for this happening with other people who might be in the same situation.
It does, certainly. It certainly does. And now, of course, when you have this prominent list of fundamental rights, this real sort of Bill of Rights of the Union, it draws much more attention.
Sure.
And member states are, well, actually nationals of member states and third country nationals even, are much more likely to rely on it. And we're going to see that we have already seen actually that the Court of Justice has started to police the boundary line between the scope of application of European Union law and what is still left to the member states more carefully in cases like the one that I have just described.
Okay. Now, why are you particularly interested in the application of the EU fundamental rights to the member states? Wouldn't you expect them to be there in the first place?
Well, in the first place, they are actually there, as I've explained, to police what the union institutions are doing. But there are these specific situations, like the ones that we have just talked about, where it's actually necessary to apply those fundamental rights to member states also. And this is very interesting because it creates I mean, it leads us to basic questions relating to the federal distribution of powers, which is an issue that you have also seen in the United States. I mean, the US Bill of Rights in the American Constitution was initially drawn up to limit the action of the federal government. And it was only with the 14th Amendment in its interpretation by the Supreme Court in the 20th century that one found out that actually the action of state and local government was also limited. Now, that may at the time have been something close to a revolution, and we are certainly not quite there yet in European Union law.
Right, okay. So what are the reasons in European Union law to apply the Union fundamental rights to the member states?
Well, first of all, there is this easier situation where the member states have to do something as agents for the European Union. And then there is this broad category of cases where nevertheless we are somehow in the scope of European Union law. And today we actually have a provision which concretely addresses this. It's Article 51 of the Charter of Fundamental Rights, which says that member states are only bound by the fundamental rights of the Union when they are implementing European Union law. So you might think that this was actually drafted to limit the application of those fundamental rights to the member states, compared with what the Court of Justice had already done in cases like the one with the lady from the Philippines. However, some of the drafters of that Charter of Fundamental Rights ensured that there was some kind of a footnote, some explanatory note, which then made a reference even to this more expansive case law of the Court of Justice. So today, it's not entirely sure whether we have the more narrow notion of implementation or also the broader notion of being within the scope of Union law. And whenever the Court of Justice in its more recent cases refers more broadly to the scope of European Union law, those that are a bit more skeptical tend to get a bit nervous.
Okay, but is this really a problem that the Lisbon Treaty brought about?
I would say it's a problem which the Lisbon Treaty accentuated, because now you really have a very prominent list of fundamental rights, and it's more likely that individuals are going to invoke them. And at the same time, you have also got this limitation in this article of the Charter in 51, which is also more prominent. So those who are a bit more reluctant to give up sovereignty are going to rely on that. And like that, you create some sort of conflicting expectations. And we have already started to see the consequences that that may have.
And what are you seeing?
Well, the consequences have been shifts in power, I would say. A shift in power, on the one hand, a potential shift, of course, from the member states to the Union. And some member states are trying to counter that. In particular, I'm thinking of the UK and of Poland, who have insisted on a protocol being added to the Lisbon Treaty, circumscribing very narrowly in which situations the Charter would actually apply to those member states. But then we can also see a shift of power within the member states. And to understand what that shift might be, one needs to look actually at the way European Union law in general is enforced in the member state. Whenever someone relies on a right coming from European Union law, for instance, the right to move to another member state and work there, the right to provide services, all courts in a member state have to enforce that right. Even the first instance court somewhere on the countryside will need to give effect to that right. And the same goes also, of course, for fundamental rights. So fundamental rights of European Union law, where they apply to the states, will be applied by all national courts throughout the Union. So the judicial review will be completely decentralized. By contrast, when you enforce national fundamental rights, you very often have specialization. You will have national constitutional courts that are specifically going to look at those fundamental rights issues, and they're going to be the only courts who do that. Now, when you are in the position of one of these national courts, you are actually going to be very interested in finding situations in which you can apply Union fundamental rights, because you're allowed to do it yourself. You don't have to go and ask some constitutional court. So these tendencies of broad, decentralized judicial review for matters of European Union law and concentrated, specialized judicial review for national fundamental rights create some tensions within the national systems of judicial protection.
I could imagine that it could have the potential of being very, I don't want to say confusing, but not necessarily fair across all of the parties involved, perhaps. I mean, is that what you're finding, that there's quite a bit of difference between how things are handled?
Well, that is one of the criticisms that are being made against too expansive case law on the protection of fundamental rights.
Mm-hmm.
Some who criticize that case law actually say that we are creating multiple forums for discussing, debating questions of fundamental rights. Mm-hmm. You don't know anymore whether you need to go to your local court, right, or whether you really have to go to the constitutional court, and what exactly is going to be the dividing line. Mm-hmm. That is one of the criticisms that one can hear, indeed.
Mm-hmm. Okay. So do you think all of this will lead to a power grab by part of the Union?
I wouldn't necessarily think so. First of all, and maybe I should go a little bit into the cases that the European Court of Justice has decided during this first time. There has been a first series of cases in which the court has been very cautious when it came precisely to the rights of nationals of the European Union, Union citizens, who were married or had some family members who were third country nationals. So a little bit the situation like the lady from the Philippines that we were talking about in the beginning. And there, curiously, the Court of Justice has come to say that those third country nationals who want to remain with the Union citizen in the state of origin, of nationality of that Union citizen, are not necessarily within the scope of European Union law. So, under the Lisbon Treaty, they can not invoke the right to family life in order to obtain a right to live and work in the member state of origin of their Union family member, which may be a bit of a reversal of the earlier case law that I've described. So that was pretty cautious, I would say. On the other hand, there is one case in which the Court of Justice has been quite expansive, and that case is, I think, worth going into for a second. It is the case of a Swedish fisherman who apparently cheated on his tax return. Income tax on the one hand, and value-added tax, which is some kind of a sales tax, on the other. So, of course, the Swedish authorities went after him and inflicted first an administrative sanction on him, and then started also criminal proceedings. And during those criminal proceedings, the national court in charge of that in Sweden was wondering whether, as a matter of European Union law, the person in question didn't enjoy the right not to be tried or prosecuted and sentenced twice. A right which is known in the US as the prohibition of double jeopardy.
Right.
So, in order for the court to address that, it first had to say that that situation was actually within the scope of European Union law. And now one must know that income tax legislation is still completely a matter of national law. So that for that part, he was certainly not within the scope of Union law. By contrast, value-added tax, this sales tax, is actually in substance harmonized at European Union level. But when it comes to sanctions, all that the rules say is that the member states have to ensure that the tax is effectively collected, and they have to prevent evasion. So the question was, is that enough to say that a system of sanctions, administrative and criminal sanctions, for avoidance, evasion of value-added tax, came within the scope of European Union law? And the court thought it did. I don't want to go into the details of the reasoning, which some commentators have criticized as actually not being entirely convincing, but I would like to underline the importance of the consequences. What this means is that whenever nowadays a claim under European Union law is enforced with the system of procedural law and sometimes criminal law in a member state, those procedural and criminal rules might come within the scope of European Union law and might therefore be checked against the Union fundamental rights. And some think that that actually goes very far. In particular, the Federal Constitutional Court in Germany has actually sent a very clear signal to the Court of Justice in a ruling in which it said that it thought that what the court had done there needed to be understood very narrowly and limited to the circumstances of the specific case, more or less.
It seems very complicated to me, the way that things are set up, where you have basically the different member states have their own legal system, which then also plays into the European Union legal system. Am I understanding that correctly?
Absolutely, yes.
Yes.
And that, I mean, that does create a lot of questions. I mean, let me just look at some of them. One question is, of course, the question of democracy, right? Normally, you would expect that you should apply the set of fundamental rights, basic rights, the right not to be tried twice, etc., which comes from the polity that has actually adopted the bulk of the rules that you're going to apply, right? It should be the same.
Right.
That would be, as a tendency, more democratic. Now, the court has tried to get around that by saying you can actually apply both, yeah? As long as you don't impair the effectiveness of European Union law, you can apply both a national fundamental right and a union fundamental right. Complicated, as you suggest, but one can maybe envisage that in situations in which we're only talking about a fundamental right coming from national law and a similar right which comes from union law, because what you could do then would be to say, well, let the person benefit from the better protection. Yeah? But as soon as you've got a situation in which several fundamental rights of various parties in a dispute compete, it becomes extremely difficult to see what better protection is going to mean. Let's imagine a situation in which one person wants to publish something and relies on his or her freedom of speech, and the other person thinks that this is actually something very private which should be protected and relies on the right to privacy.
Right.
So then, in that case, what is better protection going to be? The better protection of the freedom of speech is going to be the worst protection of the right to privacy, of course.
Right.
And in that situation, simply giving preference to European Union law in a situation which is otherwise not that closely connected to European Union law may not be the ideal solution. So the question really is, what kind of federal system of protection of fundamental rights do we want to create? In particular, one might think that there is some value in having diversity at the beginning. When you've got a certain approach towards, let's say, gay marriage in one state and another approach in another state, they can sort of experiment, and the debate that is being held in the various member states may then inform and sharpen the debate at the central level, which is something that we have seen in the US, for instance.
True.
So the question is whether in a situation like that, in which society is in a process of evolution, it is really a good idea that the Court of Justice attracts all that towards it and rules on it immediately, before giving a chance to these individual different attitudes and approaches to develop. Bearing in mind also that the European Court of Justice is not a specialized human rights court. It also does many other things.
Right. Okay, so let's take a look at the issues that you think arise from the court's approach that you've just described.
Yes, well, there are the ones that I've just mentioned here. And I would maybe like to add also that sort of a different approach, which would speak in favor of protecting union fundamental rights in the member states also more broadly, might be the situation in which, for one reason or another, fundamental rights protection in a member state fails. It just stops protecting certain fundamental rights properly. in a situation like that, which one may hope will remain entirely theoretical, of course, in the European Union, you might want to use union fundamental rights at least as a fallback. And that is something which may have been on the court's mind also when it decided to draw the scope of union fundamental rights more broadly. But in the immediate future, what I think the court will need to do is to clarify its case law more. The tendencies, the one concerning union citizens on the one hand, and the one concerning this Swedish taxpayer on the other, seem difficult to reconcile. So the court is probably going to get more questions from national courts, and it will have to refine its case law and to engage in this judicial and maybe sometimes also extrajudicial dialogue with national courts in order to convince them. So I think this is certainly going to be a space to be watched in the near future.
Right, it sounds like it will be a process that evolves over time.
Absolutely.
Well, thank you very much for being here with us today and sharing some of your work.
Thank you, it's been a pleasure.
For more information about Mr. Schima and his research, please visit our website at yale.edu/Macmillan Report. Be sure to join us again for another episode of the Macmillan Report, made possible through funding from the Whitney and Betty Macmillan Center for International and Area Studies at Yale. Thank you very much.